Welcome back to the Blackletter podcast. We set out to create an entertaining and exciting podcast about law and business. Blackletter, the name, comes from the Gothic typeset. Over time, Blackletter became the only font that English law books were printed in. It made it harder for kind of the common person to understand what the English law books said. Blackletter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify black-letter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening. Welcome back to another episode of the Blackletter podcast. Thanks for joining me today. With me, I've got Tony Brown. He runs a company that does something called patent monetization, which you may have heard of. Tony's background includes a long stint as a partner at a major AmLaw 100 law firm, Jenner & Block. And he spent time working for the government as an attorney. And after all of that, he decided that being on the business end of IP and patents was the right way to go. So we're going to let Tony talk about that. Tony, thanks for joining us today. Welcome to the show. And, I'll let you kick it off. Tell us a little bit about your background and how you got into patent monetization. And frankly, since a lot of our listeners don't know, what is patent monetization?
Sure. Well, thanks for having me on your program. I was a corporate attorney at Jenner & Block, a major law firm in Chicago, and I was a partner. And I decided that I really was not thrilled with practicing law. I was a little bit bored with it, and it seemed to me that I was doing all the work and my clients were having all the fun. So I thought I'd take a shot. And I really didn't know what I wanted to do, but I thought at my age then, which was, I guess, mid-40s type of age, if I was going to do it, I better do it then or not at all. It's pretty hard to walk away from a partnership in a major firm because you have, a lot of financial security and you don't have to worry where, your next check is coming from. I took the leap. I left the firm. And I tried a couple of things that didn't work out, but they were good learning experiences. I really think you have to fail before you succeed, and you learn as much from or more from failure as you do from success. I then was sort of wondering what I was going to do next, and I ran into a former client of mine. I had done some licensing work for him. He had developed some software, compiler software that he licensed to different people, and I represented him in licensing the software. There's no litigation involved. It was just licensing work. We bumped into each other and we started talking about potential avenues for a business venture. And one of the things we discussed was patents and how we both thought there was a lot of unrealized value in patents, intellectual property. At that time, and this was the late 80s, no one was really doing anything in the field of monetizing patents. It was the only company out there that really was doing anything was, believe it or not, IBM. They had a huge patent portfolio, not only of their own patents, but patents that they collected from other inventors. They had a storehouse of patents, and they were generating about $1 billion a year in licensing revenues. They were the original. People say that I'm the original patent troll. They were the original patent troll. They would go out and go to companies and say, we've got, 10,000 patents that have to do with your particular business. Would you like to take a license? Or, we can go through them and figure out which ones you're infringing and sue you. So that was sort of their business model. And people basically said, yeah, send me a license agreement. And they generate a lot of revenues without a lot of litigation, based on their very, significant patent portfolio. So we didn't have really a model as such because we weren't IBM. We didn't have, hundreds or, of millions of dollars to spend on buying patents. In fact, I had no dollars to spend on buying patents at the time. But I like the idea. I like the idea of creating value through intellectual property. And I did think that there were a lot of, the term Rembrandt's in the attic has been used to describe patents of particular value that people have, and they don't even realize how valuable they are because they're not in tune with what's going on in the market, or maybe they're not familiar with some of the products, but they have important patents and they just don't even know it. The business model that I came up with was the idea of trying to locate these particular valuable patents that had not been monetized, and just basically do searches on the database, the patent database, and look for interesting patents. And we did that. The fellow that I went into business with initially was more of a technical person, so he would get on the database and look through patent abstracts for interesting patents. And the idea would be that I would just, I would cold call the inventor, and I would say, what are you doing with your patent? I mean, this seems like a really interesting patent, and looks like it's being infringed by a bunch of companies. What are you doing? And the response I usually got was, "What patent?" They didn't even know they owned it. The business model I came up with, because I had very little capital. I raised a few $100,000 from friends and families to get the business going. I had virtually no employees. I had my partner who was doing the research on the internet. So, I was trying to get this thing done on a shoestring initially. So my business model was really to have the inventor be my partner. And I would take on the licensing efforts, and we would split after my expenses were reimbursed. We would split whatever I was able to recover from the licensing effort. I like that business model because it incentivized the inventor to cooperate, and to help. And it also allowed me to get control of the patents and try to monetize them without a lot of upfront cash being spent.
So, Tony, I'm going to just understand all of that's fantastic background. Just for our listeners, I'm going to ask you a couple of questions about what licensing means. I understand what it means generally, but can you explain when we talk about a patent
Yeah.
and owning a patent and how it has value and how you can get money from a company by licensing it to them? What does that really mean?
Well, a patent is an asset. It's a property right, and you can compare it to real estate. You own a building. You can live in the building, or you can rent the building. So a patent has value to gives you an exclusive right to that invention. And if someone else is using that invention, they have to pay you, just like if they were living in your building, they'd have to pay your
Right.
rents. They're using your invention, they have to pay you what's called a royalty, which is, a small percentage of the revenues they're generating from your invention. So if someone is using your invention and your patent is and you own the patent, they are supposed to pay you for the right to use that intellectual property. And so a license agreement is nothing more than like a lease in real estate, where you are entering into an agreement with the company that is using the technology to pay you a certain royalty for the use of that right.
So to break that down, essentially what you're doing when you're licensing as an attorney on behalf of the patent holder is sending letters out that are essentially lease agreements that say, hey, you're using what I own without my permission. Pay me a royalty you owe me for the period of time you've been using it. As long as I have a valid patent and something you're doing commercially reads on one of the claims inside of my patent, you should owe me money for that. It sounds really simple, right? But there's a lot more to it than that when you decide what to do before you send a letter. Isn't that right?
Well, yeah, I mean, you have to do a lot of research and work to initially determine that the patent has value. And you have to have a patent that's valid, that there's, in the sense that it's novel. There can't be prior art. You have the patent that represents the first idea for this invention. If someone had come up with the invention before your patent wouldn't be valid. It's called prior art. So if there's prior art, you have to look for prior art, understand what the prior art is, and make sure that your patent really is novel. That it's
Yep.
your inventor is the first person to have thought of this particular idea. So that's one thing. And the other major hurdle is that the whatever product or service is being offered infringes the patent. So you have to read the patent, understand the background of it, look at what's called the claims, which are like in real estate, the meets and bounds almost of the real estate. It's how you
Yeah,
define the
great
edge.
analogy. Yeah.
And you look at that and you say, okay, and then you chart it against the product that you think infringes. So every element of that claim has to be in that product. And if you've got 20 elements and only 19 are in the product, then the product doesn't infringe. It's got to be contain all 20 elements. So it's a very strict type of analysis, and there are other considerations as well besides validity and infringement, but those are the main ones. So you have to do your analysis, you have to do your research, you have to be comfortable that the patent is valid, enforceable, and being infringed before you approach anyone and say, your product infringes, pay me a royalty, because you want to be sure that you're on solid ground. So that's always a big debate, and that's where you get into litigation, because you may believe those things, and the alleged infringer says, no, wait a minute, I've got some prior art here that you didn't think about, or my product really doesn't work that way, works a different way. So I mean, what you try to do is generate a dialogue. I mean, you send a letter out, and if they come back and say, here's some prior art, you look at it and you say, okay, well, this doesn't apply for this reason, or yeah, that's good prior art, and we're not gonna try to enforce this patent. Or your product doesn't work the way you say it works. It works a different way. We can show that. So
Right.
there's a lot of.
You've got to dot a lot of I's and cross a lot of T's, right? So taking all that into consideration, Tony, what I'm going to ask for you to do when you come back for our next segment
Mhm.
is explain this in context with a case, like how you've taken your business, how you've taken a patent portfolio, maybe a specific case, so that our listeners get a sense of, how this works, and maybe a challenge that you overcame, or something that's new or different or interesting, something that you have that you personally hold that you can share with our listeners that's not confidential or subject to a protective order. Obviously, all those happy things, but anything that you can share would be great. Thanks for joining me in this initial segment, telling us about the background and how you started the company and kind of what it is that you do. And listeners, thank you for joining us again for another episode of the Blackletter podcast. You'll see Tony and I back here on the next segment, where Tony's going to do a little bit more of a deep dive with maybe an anecdotal example, an anecdote of something that's happened in his career and his venture in patent world. Download us wherever you get your podcasts, and you can watch us and find us on YouTube. Thanks for joining us again on this episode of the Blackletter podcast. That's all for today's episode of Blackletter. Thanks again for listening. Join us next time when we talk about more Blackletter issues in creative ways. Make sure you subscribe to the podcast so you never miss an episode, and check out our website at blackletterstudios.com.